Good evening, madam. My topic is Nemo Dat quad non-habit, which means no one can convey a better title than what he has. That is, a person cannot convey anything which is not in his possession. He cannot give more than what he has. But this maxim has certain exceptions. One is doctrine of election, section 35 of Transfer of Property Act, doctrine of holding out or sale by ostensible owner, which is section 41, and feeding the grant by estoppel, which is section 43. For better understanding, we have to know first who can make a transfer and what are his qualifications, which is given in section 7. Section 7 is person competent to transfer, which says that for a person to make a transfer he must be competent to contract. That is, he should be a person of sound mind. He should be a person of majority, that is above 18 years, and he should not be disqualified by law for the time being in force, or he must possess the authority sustainable in law to transfer, and he must be the owner of the property. So let's see a case regarding section 7. In BC Mandal with Indureka Devi, an agent was entrusted with the management of the property, but he tried to sell that property. The court held that the agent doesn't have the power to sell the property and is being entrusted only with managing the property. Now we will be seeing about the exceptions. The first is doctrine of election, which is section the 35 of Transfer of Property Act. The conditions to be fulfilled before the doctrine of election can apply are the following. The transfer should dispose of property which he has no right to transfer. The transferor should confer a benefit out of his own property on the owner of the property which he professes to. Sorry, the transferor should confer a benefit out of his own property on the owner of the property which he professes to dispose of. The disposition of the property and the conferment of a benefit on its owner should be part of the same transaction. The transferee put to election should have an independent property right in the property dealt with to the detriment by the transferor. The beneficiary property right should be such that the disposition of the instrument can be perfected if he waives his objection. Let's see a illustration. A, B, C. There are three persons. B makes an instrument and writes that he is transferring cash amount to A for A to transfer the for A to transfer his property to C. Now A is put into election. He has to choose between the cash and the property. He has to choose either one. He can choose either one, or he can reject it entirely. If he choose the cash, the property will be transferred to C. This is an example for election. One of the cases regarding election is Cooper vs. Cooper. In this, Mr. Cooper wrote a will and stated that after the death of his wife, the property shall be sold and the sale proceeds shall be distributed among his three sons A, B, and C. Mrs. Cooper, however, gave the property of her husband to A and her self acquired property to B and C. And after the widow's death, that is Mrs. Cooper's death, A filed a suit against B and C and asked them to elect. It was held that B and C have a choice either to accept the Mrs. Cooper's deed of transfer and waive their inheritance, or to reject the will and retain the inheritance. This is an example for doctrine of election. Now we will be seeing about uh, 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 now we will be seeing about doctrine of holding out. We will be seeing first Ram Kumar vs. McQueen case. In this case, McDonald, who had a mistress named Bono Bibi, He purchased a property in Bono Bibi's name, who was the ostensible owner. Bono Bibi, after McDonald's death, uh, sold the property to Ram Kumar, and Ram Kumar, without notice of Puno Baby being the ostensible owner, purchased the property. Later, McDonald's has sued Buno Bibi on transferring the property unlawfully. But the court held that Buno Bibi, being the ostensible owner, had the right to transfer the property to Ram Kumar, and Ram Kumar also bought the property in good faith for consideration without notice. Thus, the transfer was held as valid. Now we will be seeing about the next concept, which is feeding the grant by estoppel. Section 43 deals with it. Section 43 of the Transfer of Property Act deals with the transfer by unauthorized person who subsequently acquires the interest in the transfer. The principle is, if a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property in which he has no present title and professes to transfer such property for consideration, he cannot derogate from his own grant when he subsequently becomes entitled to the property. To understand it, we will see an illustration. For example, there is A, B, and there is two persons A, B. A is an heir, but he has not received his father's property, so he is an heir apparent. But he sells the property to B, and B buys this property without knowing that A doesn't have title to that property, but B purchases the property in good faith without any notice that A doesn't have rights to over the property and is an heir apparent. Later on, B finds out that A has no good title to the property, and he ask A to transfer the property to B, and A says that no, I will not transfer that property. But this becomes a case, and and the court says that the and it was held that the person A who transferred the title, whom represented to be as the owner fraudulently, cannot go back, and he has to transfer the property to B. This is an illustration. There is a case to this, which is Julan Prasad vs Ramraj Prasad. The mother of a minor son sold the property of the minor in the capacity of his guardian. Later the son died, and the mother became the sole owner to the property. It was held that the mother has to deliver the property to the purchaser. And the other case is Bhairab Chandra vs Jiban. A promised to transfer two shares of the property to B. At the time of transfer, A owns only one of share of that property. Subsequently, A purchased the remaining share and refused to deliver to B. But the court finally held that A is liable to deliver the remaining share to B, and this is an example for feeding the grant. This is my topic. We have now seen Nemo Dat quad non-habit and its meaning and its exception. The three exceptions are: one is doctrine of election, one is transfer by ostensible owner or doctrine of holding out, third is uh, doctrine of feeding the grant.